Mr. Johnson is now recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chenoweth, it's been said on the street many times that you and Charles Koch are best friends forever. Is that true?
I wouldn't say that he's my best friend or that I'm his best friend, no.
Well, he is your biggest funder, though, to your organization, the so-called New Civil Liberties Alliance, which sounds like it's for personal liberties, but actually it's for corporate liberties, I believe. But he is your biggest funder, is he not? Yes or no?
Well, we don't disclose who our funders are, Congressman.
And you know that Charles Koch and his...
I can tell you that over 70% of our funding meets the IRS definition of public funding.
You don't want to tell us that Charles Koch is your best friend forever, I understand, but...
Congressman, I worked
at
Koch Industries for 4 years. He was my boss.
That is a great connection that you've established, and that continues to this day, strengthened more and more.
That is not true, sir. That is not true.
Especially when you come to Congress to carry the water for the Koch brothers. They are some of the world's biggest, in fact, the second largest private corporation engaged in oil and petroleum and chemicals and fertilizer, polluting our environment, killing animals, human beings, polluting the air, water, and they don't want to have any agency.
Point of order.
They don't want to have.
Point of order.
Well, if you'd stop my time.
General Lady will state her point of order.
I believe that the accusation coming from the gentleman from Georgia is bordering on libelous, and I would request that his words be taken down. I think that he's just accused people of murder, and I think that's entirely inappropriate for an administrative proceeding.
Mr. Chairman, words can be taken down only when directed at another member of the House.
Point of order is overruled, and I'd ask members to maintain a level of decorum.
Thank you, Mr. Chairman.
Gentleman's recognized.
Now, Mr. Chenoweth, is it your contention that Congress does not have the ability to set up inferior tribunals to the Article III courts?
Certainly Congress can set up inferior tribunals, but they can't do it in ways that violate due process rights.
Article 1, Clause 8, Section 9, Congress has the ability to constitute tribunals inferior to the Supreme Court. So is it your contention that an administrative law or an administrative law judge, the office of a judge, is not a tribunal that can be set up by Congress?
Well, I would refer the Congressman to the written testimony where I explain why the Tribunals Clause from Article 1 does not, in fact, authorize Congress to give judicial power to those tribunals. These are Article 1 courts.
Are you an originalist and a textualist as well?
Say that again.
Are you an originalist in your judicial interpretation? Because, I mean, this is the clear language, a textual approach to deciding these questions can be employed also. I mean, it's pretty clear what the Constitution says that Congress is authorized to do.
That's right, and as it says in the written testimony, Congress can set up tribunals, but what they can't do is assign the judicial power of the United States to those tribunals. These are Article 1 courts, they're not Article 3 courts.
As a matter of fact, isn't it true that these administrative decisions are appealable in court?
They are appealable eventually.
And they are appealable in a de novo process.
They are not appealable de novo, sir, and in fact, the judges at the Court of Appeals, the legal determinations are de novo, but the factual record is set by the administrative process without a jury. There are no jury rights in these administrative proceedings, and so when the case gets up to the Court of Appeals can overturn legal mistakes, legal errors that have been made, but they can't overturn the factual mistakes.
Well, point well taken, but the fact is there is judicial review of agency rulemaking and agency ALJ decision-making.
Well, as I said, 98% of the folks at the SEC settle before they ever reach the Court of Appeals.
and
So
those
most of the
folks
time
tend to-
there isn't review.
Those folks who you talk about are not really just working individuals, somebody who's earning a wage. These are high-dollar, wealthy, 2017 tax cut, top 1% individuals. Isn't that correct?
Well, the woman we represented at the Supreme Court, Congressman Michelle Cochran, was a single mom accountant in Texas.
And you set that up real perfectly, too, didn't you?
Well, she came to us. She came to us because the SEC had put her through 6 years of hell, and she was not able to raise any of the constitutional objections to the tribunal because at that point, 4 or 5 different courts of appeals had said you have to go all the way through the entire administrative process for 5, 6, 7, 8, 9, even 10 years in the case of Mr. Bandemir before you're ever allowed to get to federal district court, ever allowed to raise any constitutional objections to the tribunal. And the New Civil Liberties Alliance took Ms. Cochran's case, and we pleaded with the Fifth Circuit and then the Supreme Court. You need to allow people to raise constitutional objections before they go through the process.
Perfect case that had been set up in advance and run through the process. We know how you all work.
The way that case came to us, Congressman, is that Ms. Cochran learned about Ray Lucia's case because Mr. Lucia was at the Supreme Court, and she contacted Mr. Lucia and told him about her story and said, do you know anyone who can help me? And he referred her to the New Civil Liberties Alliance. That's how we got that case, Congressman.
Certainly. Thank you, sir.
Thank the gentleman from Georgia.